to GM12, which I will go to shortly. These bids, Chair, I must stress, once submitted, are stored safely under lock and key and can only be accessed via official register through certain approved individuals within the procurement structure. With your permission, Chair, I will quickly touch on GM12, which is on the second bundle. If we're together, the second bundle is on page 132. Mentioned as GM12. You'll take note, Chair, this is the raw closing register that was finalized on the day, which was distributed to several individuals who are interested in. There is a slight difference to the one SC on Index 4 as a result of that being a typed out version and it's uploaded on the city's website. However, I can confirm that these are a mirror of each other. It's a raw document that is done on the closing day vis-a-vis on bundle number 4, something that's typed out officially and then uploaded on the city's website. It is, however, still the final closing register for the bid that is signed off and scrutinized by the relevant individuals. In this case, it runs through to page 147, and we can see the stamp of authority and confirmation that there were 57 bids that were received. Chair, I will move to bundle number 1, the sworn statement again, on paragraph 79. On paragraph 79, page 19 of the sworn statement. All bids were duly recorded and secured, and the bid opening processes were conducted in line with, I think we've dealt with 79, Chair. Let's move over to 20, where we deal with 80 on the extensions. This tender, Chairperson, was subject to extensions on 3 occasions: 31st of March 2025, 29th of June 2025, 27th of September 2025. All these extensions, Chair, I can confirm, were done in line with the city's supply chain management processes and procedures and policies under the delegated authority of the Director Acquisition Management. It must be noted, Chair, that the extension process falls under or within the prescribed SCM delegation framework, and I, in my capacity as the Chief Financial Officer, am not involved or responsible for the approval of such extensions. It is a delegated function. Paragraph 80 and 83, I now touch on the bid specification process. On this bid specification process, Chair, I think we've had the pleasure of looking at GM 9 and 10 as well earlier on. The bid specification process duly was considered and approved the terms of reference of TMPD 01 pertaining to the provision of services for the monitoring and prevention of illegal land and building occupation, as well as demolition of unlawfully erected structures within the city of Tshwane on the 19th of September. This committee was constituted by 7-member panel chaired by Mr. J.M. March. The official minutes of the bid specification committee are attached herein as GM 9 and 10, where the details of the tender are recorded. I think we have touched on GM 9 and 10 previously, Chair, and what was essential for me to bring the members of the commission and the evidence leaders on board is that this was a process that was undertaken by a separate committee with from an independent perspective. They had completed their declarations of authorities in accordance. So I would not want to waste the chairpersons of the commission's time by referring back to GM 9 and 10, which we have touched on the summary document. On 84, I want to touch on the bid evaluation committee processes, which I will refer us later on to GM 13 as well as GM 14 in the second pack. Chairperson, on 84, I state under oath that the bid evaluation committee was duly constituted and comprised of 6 members chaired by Mr. Victor Hopper, and they commenced their work on the 21st of August 2025. The composition of the BEC ensured appropriate representation from supply chain management, the user department, as well as the department responsible for this tender, thereby promoting objectivity, technical competence, and compliance within the city supply chain management framework to ensure that this is not a group financial services matter. It is a function that must be undertaken by TMPD, Department of Human Settlements, and all relevant departments who make use of the tender and who own these tender processes. Within these processes, Chair, the bid evaluation committee convened on several occasions, like I've stated, to evaluate the bid in accordance with the prescribed evaluation criteria, including administrative compliance, functionality, and preferential procurement requirements. Following to its deliberations, the committee presented its findings and recommendations to the Bid Adjudication Committee on 3 separate occasions for consideration and further guidance. The final Bid Evaluation Committee reports have been attached as Annex GM 13 as well as GM 14, which I would want us to refer back as the Commission in order to take note of what actually happened here and what were the terms of reference of this separate committee and what were they doing. Chair, 13, Chair, on the second bundle, it's on page 150. On page 150, Chair, we give guidance that detailed bid evaluation committee report that was presented to the BAC on the second occasion. Within this, Chair, what I want to bring on board is the work of the BEC and what they're responsible for. The work of the BEC is to ensure that they look at the established scope of reference. I'll refer you for argument's sake to page number 7. On page number 7, at the bottom, on page 156, we start looking at the key requirements for this particular bid on 3.5.1 on the personnel that might be required per region and what the key requirements would be for any bidder to be successful in terms of passing the stage on the personnel perspective. Further move on to 352 in terms of equipment on 157. We elaborate in detail, Chair, what type of equipment must be brought on board, how many vehicles required, what other specifications of various contact information must be brought on board for this. Further to this, Chair, I want to take us to page number 12, for argument's sake, where we summarize now. On page 12, it's on 161. And I'm dealing with this on purpose, Chair, to try and give an indication of the segregation of duties and the work of compliance that must be undertaken by this independent committee who does work under declaration and oath as well. Then need to ensure on page 12, for argument's sake, that the schedule of particulars and personnel and vehicles that are required in each of the regions for prospective bidders. 1, there must be guards from a grade A, for argument's sake, grade B, and from a supervisor level, both day and night shift. 12, grade C, 9, grade C, day and night shift. We then move over to page 162, where we break down the stages of evaluation. On page 162, we look at the 4 stages of evaluation. This tender was subjected to a 4-stage bidding process where firstly, administrative compliance requirements had to be facilitated by the BEC. They had to ensure that mandatory requirements are dealt with accordingly. Physical site inspection to validate the submissions and the POE that have been brought on board by various bidders in terms of vehicles that they say they have, that they claim they have, from the INATA certificate. We had to ensure that site inspections are done to physically validate this, as well as the guns and the weapons. Lastly is the preference point system that's brought on board. The point of me raising this, Chair, is the rigorous process that is undertaken in terms of completing bids of this nature. Now, we'll just look at an example of one such example on a bid that's been completed. And when doing so, Chair, I'm going to refer you, I'm going to pass the pricing schedule and all those nitty-gritties to page 180. Page 180 of the second bundle. Page 180 of the second bundle is a pre-compliance assessment once we get there. So this is a pre-compliance schedule that is done independently by the committee that I've referred to, the BEC, where they clearly scrutinize whether bidders have clearly outlined or provided their CSG.
Sorry, Mr. Mnisi, again, apologies for interrupting. Bear in mind that the pagination that the commissioners are using doesn't include the 2 pages of index at the front of, in the case of this bundle, the 2 pages of index. Okay. So if you can just deduct 2 pages from your references when you're referring them to a specific document. Right. So your pre-compliance schedule will appear in their bundles as 178.
Okay. Maybe I think what I'll also do, I'll wait for the screen to guide me on the same page.
We have it the way he's been giving it to us.
then I'm the one with the wrong papers.
We have the item 3 pre-compliance schedule. It's on 180.
Thanks. I'll try and sort my own papers out later. Sorry.
If we run into difficulty, I will let you know.
Okay.
But we are following.
Okay. Thank you, SC. So the purpose of pre-compliance is to already deal with issues that are non-compliant, to start the process of eliminating bidders that shouldn't be able to make it to the next stage of administrative compliance. BEC and the members that have been appointed, I'm going to reiterate, are made up of individuals from supply chain management, TMPD, the user department, as well as the departments who regularly utilize or make use of this tender. It's a multidisciplinary structure, form of individuals and expertise who are together involved with dealing with these matters. This is just an example, Chair, that pre-qualification stage, a number of bidders are already knocked off as a result of them not being non-compliant to many issues and not attending the compulsory briefing session, for argument's sake. We then move on, Chair. On purpose, I want to take us to page number 187.
Mr. Mnisi, maybe before we do page 187, if you would just explain the pre-compliance criteria, what it is that is looked at to disqualify people, because there are specific topics at the top.
Yes.
I don't know if this is all of it or not.
Okay, yes, indeed, Commissioner Baloy. From a pre-compliance perspective, we check whether the company declared CSD number. This is to confirm whether they are registered on the National Treasury's centralized supplier database. The second aspect, we refer to them being a restricted supplier. There are suppliers who are blacklisted from doing business with the state. From a pre-compliance perspective, it's essential for the bid evaluation committee to conduct a validation check whether any of the prospective bidders are listed among the prohibited bidders as designated by National Treasury. Second component, state employees. We don't do business with state employees. They need to conduct an assessment from a pre-compliance level before we even move to administrative requirements, whether any of the bidders, directors, or associates are state employees. A tax compliance schedule is done at this stage as well. Does not necessarily mean that bidders are excluded as a result of Section 43 of the MFMA, which we'll discuss later on. We allow bidders an additional 7 days, but it's effective to take note of this, Chair, so that from an initial submission perspective, all structures of BEC, BAC, and the accounting property teams and the accounting officer are aware that at this point in time, this bidder was not compliant. The second aspect is that if there is a joint venture, there must be an approved joint venture agreement as well as joint CSD, joint BE certificate for preference point systems. Then lastly, it's effective for us to take note whether did these bidders attend the compulsory briefing session. There is a compulsory briefing session. If you don't attend that clarification engagement, you are disqualified at this point from the onset.
Thank you.
Chairperson, I'll then move further to page number 187. On 187, we start looking at the administrative requirements now. The key items of completion from administrative requirements. Bidders must ensure that the minimum bidding documents are fully completed. MBD 1, for argument's sake, must be completed in full. MBD 4, which references declaration of interest, must be completed in full. Bidders must provide other entities which they are directors in. They must equally provide those MMA numbers from registration with the supplier database from National Treasury. They must further ensure that the declaration of procurement of any procurement of above 10 million rand is included as MBD 5. MBD 8 is an essential to declaration of past SCM management experience. MBD 9 is an essential declaration which certifies the independent completion of this tender. The joint venture agreement is an essential matter of consideration. And the last essential administrative requirement, Chair, is the pricing schedule. Pricing schedule must be completed in full. In the instance where some bidders do not complete a price, they must put a dash or indicate that it's not applicable. This is to avoid issues if they are an appointed bidder, they now claim that they did not complete all prices in full, but then need to revisit the process. So we dictate that the pricing schedule must be completed in full without any mishaps. This is also, Chair, an effective process that is done independently by the bid evaluation committee, which is comprised of those individuals from supply chain management, the user department, as well as the tender owner. In this case, TMPD, it's a multitude of individuals who sit and assess these requirements independently. The second stage, which is essential, Chair,
Sorry, Mr. Miss, where that heading, certification of independent tender determination, who does that? Is it the bidder that does that certificate, or is it an internal? What does it mean, in fact? Maybe let me ask more simply.
It's the bidder, Chair. In short, they make a commitment that all the information completed here is from us as the bidder, and we stand by it.
Okay, thank you.
Chairperson, I'm now going to move on page number 195 of the same pack. This pack now details a list of bidders that have been disqualified as a result of them being non-compliant to the administrative requirements that we've listed above. State all the bidders on board, and they list the reasons on which of those 7 administrative-related matters the bidder did not comply to. Multitude of reasons are provided. It is fully aligned to the schedule that is provided above. It also demonstrates that due diligence is done in terms of double-checking with the work of themselves, that the BEC have in fact disqualified the correct individuals in line with the schedule that has been prepared earlier on. So now, Chair, the bidders who remain and move on from administrative to mandatory compliance are the bidders who have passed the stage of administrative requirements. These are now listed from page 198. So, Chair, the purpose of me doing this is to outline the process and procedures which might be followed to validate the process is done A to Z to the T, and there hasn't been any glitch or mishap throughout the process. We're now sitting on mandatory requirements on page 198. On page 198 now lists the bidders on the top, and it gives the key mandatory requirements as a column, on your column towards your right. I know this page is upside down. However, the BEC, which is comprised of a multifaceted individuals from all departments within the city, then conducts an independent checklist of each bidder that's remaining. So, okay, we are now left with bidder 2, 12, 15, 19, and 21 on page 198 for argument's sake. The minimum requirements is, firstly, the bidders must have a CIRA certificate. Do these bidders have that? Conduct the checklist, Chair. This is all under oath. There are declaration of interest that are completed by all members of the BEC. Mandatory requirements are completed accordingly from 1 up until, I think, 11 for bidders 1 to 21. Demonstration that an independent process is done, and we are still within the key requirements of the legislature process of awarding bids of this nature. If we move on for argument's sake to page 199, just to give you a picture of bidder 19. Bidder 19, for some reason, does not provide photographic evidence of vehicles as required in the specifications, meaning there's a glitch here, and it's an area of concern, which means you might not be able to pass and go to the next stage, as well as the liability insurance of 10 million rand. It's already an indication to me that bidder 19, without saying his name, will be disqualified from the process for failure to adhere to the key requirements as designated by the mandatory requirements. So, Chair, that's the process that is undertaken for all bidders, which then gives us guidance to move on to the next stage. With your permission, Chair, I will now take us to page number 206. Same bundle. At the bottom of page 206, we now give a clear explanation of the bidders who now did not meet. At the bottom column now gives explanations of the bidders who did not meet the mandatory requirements. They might have passed administrative pre-compliance, they might have passed administrative compliance stage, but when we got to mandatory requirement stage, they failed due to a multitude of reasons as displayed earlier on. So the bidders that are listed here, which is 12, 19, 44, 51, and 54 for argument's sake, do not meet the mandatory requirements. They are disqualified from the process moving forward. On 207, we now give an indication of the bidders that are moving on to the next stage. This is on page 207. The top is a tabulated, it's a table that informs bidder 2, 15, 21, 23, 26, 32, 35, 36, and 40 that are compliant from a mandatory perspective. This means these bidders that we're looking here up in front of us are compliant from pre-compliance perspective. They have met the requirements from administrative compliance. They have met the mandatory requirements. They now be moving forward to the next stage, which is a physical verification, where the members of bid evaluation committee, I'm going to reiterate, Chairperson, they're made up of multifaceted individuals across the city, from supply chain management, TMPD, as well as the user departments are responsible for utilizing this tender, then must go out on site and conduct physical inspections and validate whether the vehicles that have been provided as part and parcel of the bid are actually those vehicles, and whether those vehicles meet those key requirements. Similarly to issues of weapons and other matters that must be validated from a physical verification perspective. That process is then undertaken accordingly, Chair, and I will now move to page number 2111. On 2111. 211.
Oh, you said 2111.
Sorry, Chair, 211. On 211, we now designate the results of the physical verification that was done by the Bid Evaluation Committee. Bid Evaluation Committee went out on site, inspected all the individuals who had passed the first three stages of the legislated supply chain management process and procedures. Bid number 21, for some reason, does not have a number 5-ton truck as designated within the bid that was submitted. They then need to be disqualified as a result of not meeting the requirements from a physical assessment perspective. We're now remaining on table number 7.2 with about 8 bidders who are compliant from a site inspection perspective, who must therefore then be evaluated further on stage 4. Stage 4 is when we consider pricing and preference point systems. Bidder 2, 15, 23, 26, 32, 35, 36, and 40, Chair, are now the bids who have passed the process from A to Z and at the last stage where they are evaluating the procurement process. So, Chair, the process of me taking the commission through this process is to try and designate the segregation of duties, one, the compliance process that must be followed by the Bid Evaluation Committee, and to give an indication that throughout this process that I've just mentioned, from pre-compliance, in fact, from the closing register up until the Bid Evaluation Committee, I've got no involvement whatsoever. I've got no access to any of these documents whatsoever. They are under key and lock, and they are made available to designated individuals only.
Mr. Mnisi, do you play any role in the appointment of the members of these committees?
No, I don't. Members of these committees are appointed by the city manager. They are representatives and they are seconded by the departments. So I'll give an example. If there are members from TMPD, the chief of police must give us individuals. We have put these systems and internal controls on purpose, Chair, in order to avoid a situation where we handpick individuals who might be favorable to anyone. The chief of police will be responsible for providing individuals who are from TMPD to sit on BEC. If it's human settlements who's involved as well, group human settlements department must second individuals who will serve in PEC as well. And then the chairperson and the secretary of these committees are appointed by or are seconded by the supply chain management team.
So it goes directly to the city manager. You don't play any role at all, not even advising the city manager.
No, I do, Chair. The list, I'm CC'd on that, and I do confirm that we did receive a list from the various departments, and this is a list that the city manager can endorse. I do advise and I do recommend it.
So it's not a passive role, then you do play a part in advising the city manager on the suitability of the people who are nominated to sit in either of these committees.
Maybe let's put it this way, Chair. I'm always carbon copied on those matters, and when there's a dissenting view, I raise that. And in this instance, when I'm carbon copied and I see the list of individuals, and I'm happy that the process has been followed and that the relevant departmental heads have recommended individuals, I endorse it and I have no issue whatsoever. In the event I am made aware or I see in the process that this is a tender that is utilized by 4 groups, but there are only 2 departments or representatives, I then raise concerns accordingly. I think my role is to make sure and validate whether we have given a view and an opinion from the user departments to second individuals they deem are compliant to serve in these committees.
Thank you.
So there has been instances where I would say, no, Chair, I'm not convinced city manager with this list. You can't approve this. I'm not seeing representatives from group A, B, or C. They are users of this tender.
A related question, Mr. Mnisi. In paragraph 84, where you speak about the composition of the BEC, you say that among others, there will be the user department, and then you say, and the department responsible for the tender.
Yes.
Is that still, that second part, is that still the user department or is it a different department, and what is their role when you say responsible for the tender?
So responsible for the tender in this case will be TMPD. They are the ones who are designated the responsibility. In place, human settlement departments normally bears the branch and they are affected. So they make use of the tender as human settlements or shared services, but the owner of this tender is TMPD. So they make available some sort of funding to ensure that this tender is executed accordingly.
I see. Thank you.
Chairperson, I've covered now the essence of GM13. GM14 is a similar document, and it makes reference to a further report. In GM14, it's the final BEC report that has served to the Board Adjudication Committee. The entire process has been concluded, Chair. I'm just going to find the page. It's on page 244. So the major difference from GM14 to GM13 is that GM13 is served at BAC, which I will outline later on. BAC found a number of non-compliant issues or concerns which they were not covered with. GM14 now covers those issues of concern that were raised by BEC. So you will see the difference that they bring on board is a further report. And this further report touches on the areas of concern or the areas of non-compliance that had been previously raised by the BAC and referred the matter back. We will touch on the 3 instances where BAC said, and we will delve on the reasons in detail. I'm just giving the Commission an example that if BAC, for argument's sake, take note that one bidder has been disqualified for an administrative matter, but there's no proof in the report that it's been provided. It is questioned and the reports are referred back accordingly. So GM14, I'm going to go to the picture where it gives us a further report and how the issues might have been addressed. Just going to find that page for the Commission. There we go. So, Chair, on page number 329 of the second bundle. 329. On 329, it comes back as a further report, and this is the major difference because this is the final report that serves at BAC now. It says this further report, matters raised by the BAC, 1 to 6. This was the issue that was raised. These are the responses that we are bringing on board as BEC.
Sorry, Mr. Minister. Before going directly to GM14 from GM13, should you not have gone back to the narrative at page 21 and picked up from 84, which would then take you to GM14?
Chair, I think what I was trying to do is GM13 is a BEC report that was referred back.
Yeah.
So,
you see, my difficulty is you refer us to a report that comes in after there has been some decision, preliminary decision by the BAC, if I understand you correctly.
Okay.
That's my difficulty because you have not told us anything about the BAC getting involved at this stage. So it's been BEC throughout. Do you get me?
I get you, Chair.
Yes.
So on my statement, Chair, I start covering the events of the BAC from page 22, where I deal with each of the events. So I'm not sure you would want me to deal with just...
Is it not page 21, paragraph 84?
Yes, page 21, paragraph 87, 21, 87. On the first bundle, on my sworn statement, I start dealing with the process of the Adjudication Committee. 21 of my sworn statement, paragraph 87. So I'm almost getting to your concern, Chair, where we'll outline each.
Okay, maybe let me hear you out, yes.
So I'm concluding on GM14, and I'm saying on GM14, the purpose and the difference between GM13 and GM14 is that it comes as a further report now. BAC have raised concerns. I will outline on these concerns on each of the 3 occasions soon, Chair. They have raised concerns. BAC is now coming on board and saying, we have dealt with these concerns. This is our responses. It's then retabulated to BAC, and this is the final BEC report that was considered and approved. So now, Chair, I would like us to go back to the main statement on page 21, where I would outline now the Board Adjudication process, as well as the 3 sittings that's set, which one now will tie your concern in terms of what happened with that report, why was it not approved, and why was it returned back, and of course, obviously, how it was remedied moving forward. On 21 of the main bundle, or the sworn statement, I now deal with the bid adjudication committee process. The bid evaluation committee presents its evaluation outcomes and recommendations to the bid adjudication committee. On this instance, it was on 3 occasions for this tender, Chair. It was on the 4th of September, 2025. It was on the 18th of September, 2025. It was on the 25th of September, 2025. On 88, I cover in summary that on the first 2 occasions, the matter was referred back to the BEC. This includes GM 13, Chair, where the matter was referred back to the BAC for further clarification, refinement, and alignment with the applicable supply chain management requirements. The bid evaluation committee duly considered the BAC's input and effected the necessary corrections and enhancements to the evaluation report, ensuring that all compliance, technical, and governance aspects were adequately addressed. Further to that,
Before you go into the next paragraph, and you don't need to refer us to the document if it's not necessary. The power or capacity of the BAC
yes,
to refer back to the BEC, where is that contained in the SCM policy?
it's in the delegation of authorities, Chair. When systems of delegations, the roles and responsibilities of the bid adjudication committee as per the MFMA, those are delegated. These are functions delegated to the city manager, who further delegates them further to myself, who I serve as the chairperson, as well as other members who are serving on the bid adjudication committee. So the real reason for referring back, if we see issues of non-compliance, if there's errors of non-compliance to the prescriptions, the MFMA regulations, as well as the policy, we are entitled to refer that back and not advise the accounting officer to appoint as a result of glitches which might not have been clarified by the BEC at that stage. So those functions are as per the MFMA delegations, delegated by the accounting officer to the bid adjudication committee. They are clear in the appointment letter that it gives to members of BAC committee as well, in terms of your roles, your responsibilities, and the key functions that you must execute.
Okay, I don't know whether it's me not understanding your answer or maybe I didn't express myself properly. What I'm trying to understand is when the BAC
Yes,
exercises a power to refer back to the BEC, where is that contained? And I ask the question because I'm aware of some instances in another city where a BEC, after the BAC referred back to the BEC said, no, we've done our job. We are not going to look at this again. We don't have the power to look at it again. You must make your decision based on what we've submitted. So I'm aware of that kind of experience. It's that kind of question that I'm trying to determine whether your SCM policy authorizes the BAC to refer back to the BEC instead of just making a final decision on the basis of the report that you have. You understand what I'm asking?
yes, Chair, understand. Okay. So, Chair, I can confirm the policy is clear, and the policy makes reference to the BAC performing its function and ensuring that the process has been followed to the T without any glitches or shortcomings. If the BAC picks up shortcomings within the process, we are entitled to refer that back for clarification. Before we refer the matter back, you must be aware that the individuals from the BEC are given an opportunity to clarify on the spot. We are here today at the Commission. You asked me for a relevant section in the MFMA. I say, Chair, I'm not aware of the actual section right now. Can I come back to you? So back to the BEC perspective. BAC will say, where is the property report in terms of this bid? Or the property raised these concerns. Have you addressed them accordingly? We're not seeing this clearly stated in the BEC report. The BEC is there to answer that question. If they're able to answer the question, we are then satisfied with the response and the procedures move further. If they're unable to answer that question, Chair, we're then at a standoff. And this is when we refer matters back, when answers are not readily available by the BEC, or whether the BEC themselves need to reconstitute in terms of responding to the BAC on that particular query. This also happens from the accounting officer perspective, Chair, where the BAC would conclude on an award. The accounting officer's got the power to refer that back and say, I'm referring this back. I'm not certain whether you have covered area 1, 2, or 3. or within the mandatory requirement stage, I'm not convinced that bidder number 2 has complied with these issues on board. So that also happens on a regular basis. BAC is able to respond. If we respond accordingly, the accounting officer then okays that response and approves. So in this instance, the answers from the BEC were not readily available. Hence, the matter was referred back, and the BEC accepted, Chair, that this is something that we need to look at. This is a compliance glitch that they might have overlooked as well. Or the report was not clearly stated on how they addressed matters of that nature. The nitty-gritties are essential, Chair, because the city is always embroiled with legal battles with service providers as to why they've been disqualified in some instances, and in some instances, why others are appointed. So these decisions that are taken must not be subjective, it must be objectively stated within that. I'm not sure if that covers you, Chair, Commissioner.
Okay, look, I think we'll discuss it further as you testify, but I hear your answer.
Chairperson, I was on item number 88, where I concluded that on the first 2 occasions, the matter was referred back to the BEC by the BAC for further clarification, refinement, and alignment to the applicable supply chain management requirements. The BAC duly considered the BAC's input and effected the necessary corrections and enhancements to the evaluation report, ensuring that all compliance, technical, and governance aspects have now been adequately addressed. On 89, attached, following the incorporation of these revisions, the BAC resubmitted the matter to BAC on the 25th of September. The BAC was satisfied that all outstanding issues had been appropriately addressed and resolved. The BAC subsequently approved the recommendation, resulting in a formal signing of the resolution and its submission to the accounting officer for further consideration and approval in accordance with the prescribed SCM delegation framework. Chairperson, with your permission, I now deal with what transpired on each of the days, on the 4th, the 18th, and the 25th at the BAC itself, what really transpired on those separate dates. And I will refer you to several annexures which will also answer your concerns on GM13 and the reasons why that was referred back.
Sorry, Mr. Mnisi, sorry to interrupt, but we've got a practice of taking a tea break at 11. So I think if you're going to shift to each of the BAC meetings, it may be convenient to take the tea break before you do that.
Thank you, Mr. Chaskalson. Let us adjourn and resume at 11:35.
an explanation as to why the highest scoring bidder has not been
Can
recommended.
you please explain the concept of as and when pricing?
So, Chairperson, it's a rate-based appointment, meaning there will not be illegal invasions every day. So if we do an appointment without clearly stipulating as and when, the bidders might take advantage of that and submit a monthly invoice, even when there was no work that has been done in terms of removal of illegal structures and invasion.
Oh, thank you, thank you.
The third aspect is that we as BAC were fully aware that this bid underweight property. However, the final property report was not provided to the BAC at this stage, confirming that all the concerns that were raised had been addressed. Concerns in terms of service provided used across all regions was a massive provision which wasn't catered for in the specifications. There was no clarity in terms of methodology used in terms of allocating regions to specific bidders. On the basis of that region, Chairperson, it was resolved that this tender be referred back by the acting chairperson of that day, as I was not in. I am the chairperson of BAC. If I'm not in, I am delegated to appoint an acting chairperson. On the bid adjudication committee, we sat on the 4th of September. The governance and support officer, who is a senior manager, was acting as the chairperson of the day.
But you were part of the process. It's just that when the document was signed, you were not there on the day.
No, Chair, I was not present at the BAC that sat on the 4th of September. I had appointed an acting chairperson to preside over the meeting on my behalf.
Again, it's just to try and understand how it works. So where you were reading now, second bullet, for example, it says the report does not provide, this is the BEC report you're referring to, it does not provide any explanation as to why the highest scoring bidder has not been recommended. Now, isn't it the function of the BAC to make its own determination on the basis of the report that you have received? Because you've received a report, and then you have members of the BEC, as you explained, attending that meeting. You ask them questions and they respond and provide clarifications. If the report of the BEC, according to your determination as a BAC, there's the highest bidder who should have been recommended, is that not a determination that the BAC then makes instead of referring that back to the BAC? I'm just trying to understand how things work in practice, in fact.
In practice, Chair, had the BAC make a determination, there will be a breach in lines in terms of the delegation of authorities. 3 processes can be undertaken from a BAC. You can recommend for the award, you can cancel the bid if the irregularities or the issues picked up are uncurable in nature. 3, you can refer the matter back to the BEC for reconsideration. So in this instance, there was no certainty as to why. The report was not substantive in terms of why is this bidder, who appears to be the cheapest, not awarded. Yes, as the BEC, you give us a letter saying this particular bidder had confirmed, you tell the BEC that the bidder said they're unable to deliver. Their prices that they quoted, they will not be able to execute the work, but that's not attached in the BAC report, meaning when you do come back to BAC, we expect that letter authorized by that specific service provider who was the highest scoring bidder at this stage. So we don't make a directive because there will be a breach of process. We have to allow the BEC to make a determination. There must be consensus throughout the process. We make a determination, in some instance, it might not be well informed. So we need to ensure that the committee reevaluates this. They could come back to BAC and say, this bidder has not been awarded because of these reasons. We'll then have an opportunity to interact with the reasons that have been provided, either agree with them or disagree with them on the way forward. If this issue, for example, were to come up on the second round, Chair, and we're still uncertain, BAC could make a provision that we are now either uncertain whether we could proceed with this, irregularities that we are identifying are not cured, we would recommend for a cancellation of this bid. Or we have now received adequate explanation in terms of why this higher scoring bidder was not awarded, at which stage it might have fallen off the bandwagon, and then move ahead with the recommendation. So we'll not give a directive, we'll allow an opportunity for the committee to elaborate on this matter so that there's consensus throughout. We wouldn't want to force a decision down a committee, Chair. The delegation and segregation of authorities don't allow that at all.
Okay, thank you.
Chairperson, I will now move back to the sworn statement on page 24. I am proceeding to the second bid adjudication committee, which set on the 18th of September on page number 24. So on page 24, the BEC comes back. Again, Mr. Victor Hopper, who was the chairperson of the BAC, comes to BAC. During his deliberations, the BAC raised several concerns relating to the compliance, property, and transparency of the evaluation process. The committee emphasized that the requirement, once issues raised by the property team have been addressed by the BAC, a final property report must then be brought on board to give confirmation that indeed the identified concerns have been fully resolved. Chairperson, in this regard, the BAC noted that documentation provided on validity extensions reflected responses only from 5 bidders rather than all 57. There were no formal communication received from the probity audit team, the independent external probity audit team, that the matters that had been raised have been adequately resolved. On 97, I further state that the BEC resolved that the tender remained valid until the end. They responded that the tender remained valid until the end of September, and that the recent extension was just a precautionary measure to ensure that the validity upon finalization. It further undertook to ensure submission of all outstanding bidder confirmations, which it did. 98, the bid evaluation committee also highlighted the need for greater clarity and transparency in the report, particularly regarding the methodology used to allocate regions. This comes up again as an issue which is not clearly dealt with as from the first referral back. The BEC indicated that the bid specifications did not prescribe specific allocation criteria. However, other than limiting bidders to one region, the bid evaluation committee then decided to utilize the preference point system, which will be applied in terms of determining allocation of bidders, meaning 7 regions, 7 bidders, higher scoring bidder from 1 to 7 will be allocated in that order. 1, region 1, 2, region 2. That was the preference point system that were to be outlined. However, Chair, what the PAC took note of is that this application system was not clearly articulated in the report. The report that they're bringing to BAC now, yes, they are responding to us and they're telling us in the BAC, but it's not clearly articulated on the process of utilizing the preference point system to allocate bidders to regions. Additional concerns, Chair, were raised regarding the rationale for engaging in price negotiations only with certain bidders and not all, as well as inconsistencies identified in the property findings. Specifically, the BAC noted a discrepancy where a bidder which was flagged by the property team for non-compliance was nonetheless recommended for award without adequate explanation. This was a major red flag from us, which indicated that there was an inconsistency on the property report and what the BEC was bringing to BAC. In paragraph 100, I summarize. In light of these concerns, the BAC resolved to refer the report back to BEC on the following directive. 1, provide clarity on the apparent inconsistency regarding the recommendation of a bidder previously disqualified by the external independent property team. Obtain and submit a final property confirming that all issues have been dealt with satisfactorily. Clearly document the methodology which will be applied to allocate regions to suppliers as per the preference point system that you are verbally telling us now. I'm then going to refer us to GM16 on the second bundle, which outlines the resolution that was taken by the bid adjudication committee. Again, Chair, referring this report back in light of those discrepancies that were noted. GM16 has been captured on page 348. So you'll see now that there is improvement in comparison to GM15. Firstly, there's no blanket amount that is now given to each bidder. In the previous GM15, you would have said region 1, bidder 15, a holistic price of 250,000 for argument's sake. Now it's clearly articulated on what the pricing for personnel is, what the pricing for vehicles is, what the pricing for additional vehicles are, and it's on an as and when basis. I'll move further, Chair, in terms of that major difference in articulation on the improvements that were done by the BEC towards page number 353. Well, let's start at the bottom of 352, where during the discussions on the matter, the bid adjudication committee meeting held on the 18th of September, the committee resolved the following. I've touched on this in my summary that after the findings provided by the property team, they had been addressed by the BEC. The property team must now provide a final report giving us assurance. You can't just tell us by word of mouth as BEC that property team have confirmed the report is now fine. You can approve. We needed portfolio of evidence to convince us as the BAC that indeed that certainty was obtained. Second point was, in terms of the probity team raised concerns on the validity of extensions, and the committee further noted that supporting documents in terms of validity extensions attached only for 5 bidders. Therefore, confirmation had been provided to the probity team, and this matter was resolved. Adequate evidence was provided within this BAC. We were comfortable with that. In their response, Chair, the BAC indicated as well that the tender was still valid. This was only a precautionary mechanism. However, I think what's key is in reference to the preference point system, which will now be utilized in breaking down the award of each. This is now captured on page 353, where that how the preference point system was applied should be included in the report, which is a significant determination on what we should do, Chairperson. There were also concerns raised in the report that do not provide reasons why the BEC negotiated with bid number 36. There was no adequate reasons for whom they considered prices to be high, but have not negotiated with other bidders like bidder number 40. It was very odd for BAC. Why wouldn't you conduct a bid negotiation for all bidders who are subjected to our prospective bidders? Similarly, on 21, that in their response, BEC indicated that they compared the VAT exclusive and inclusive price and benchmark provided by the department and the sourcing strategy as per the BEC report that I indicated earlier on, and noted that the inclusive price or NIST were higher, therefore opted for negotiation on this. They were of the view that bidder 40, for argument's sake, was within the sourcing strategy and was not above the pricing. But now on page 21, on the property report, clearly indicated, Chair, that bidder number 2, without mentioning its name, well, I think I should, that on bidder number 2, Vimtsiri Security and Protection Services, Chair, did not submit 3 years audited financial statements. This is what was indicated in the property report, mind you. However, they were disqualified, indicated the bidder did not have a 5-ton truck, therefore were disqualified. However, the bidder is being recommended for Region 5. That was a major concern that BAC had picked up, BAC had raised, we therefore had to refer the matter back. So in short, on 354, it was therefore agreed that the report be referred back to the BEC for them to consider the following. 1, provide clarity regarding the disqualification from the property team, where the external property team says, bidder number 2 of Vimtsiri Security Services might be disqualified, but the BEC in any case moves ahead with the recommendation. Major concern for us, we couldn't agree to this, it was referred back. Obtain a final property report, confirming that all matters have been addressed. Remember, I indicated, Chair, earlier that the BEC verbally indicated to the BAC that this bidder number 2, the matter was deliberated with the property team, it was effectively dealt with and they were compliant. However, we couldn't rely on that. We needed physical evidence in the form of a property confirmation report as we would normally have. Include in the report how preference point system would be applied. For those reasons, Chairperson, we therefore referred the report back. We'll take note, Chair, that I was back in this sitting. I was chairing this sitting of the BAC on this day, on the 18th of September, 2025. Chairperson, I will now go back to paragraph 101 on page 25. I now deal with the outcomes of what transpired at the BAC on the 25th of the final BAC now, which sat considering this matter on the 25th of November, 2025. The report was presented by the BEC chairperson, Mr. Victor Hopper, to the Bid Adjudication Committee at its meeting held on the 24th of September, 2025. During these deliberations, the BAC took note of further issues that bidder number 32, El Shaddai Security Services, bidder 35, Ngapashia Construction and Project, as well as bidder number 15, 2 Corps and Security Services, at this stage were non-compliant at the time of evaluation. Accordingly, the BAC directed that the provisions of SCM Regulation 43 be applied for these bidders. The committee further noted and accepted that the confirmation that all issues previously raised by the probity team had been satisfactorily addressed, as evidenced by the attached final proactive forensic assurance review addendum report that was provided, giving the BAC assurance that all these matters have been dealt with accordingly. On 105, I conclude on the outcomes of BAC that in light of the above, the BAC finally approved the recommendations of BAC subject to the implementation of Regulation 43. It was further noted that subsequent to verification through the centralized supplier database system, there was confirmation that was received that affected bidders were now tax compliant. The resolution of this sitting, Chair, has been captured as Annex GM 17. With the permission again, Chair, I will request that we move over to bundle number 2, to page number 355, wherein I want to take the committee through GM 17. So in GM 17, final resolution, and maybe we can start at page number 366. This is the final report that was now recommended for approval. It was recommended by myself as the chairperson of the BAC to the accounting officer for approval. It was subsequently approved after validation and confirmation by the accounting officer. So going up, Chair, in terms of the content of this report, BAC had taken note that all issues that had previously been raised have been adequately addressed. One, the issue where a property concern, which was identified, and there was confirmation received from the property team in the form of forensic assurance review report as an addendum attached by the external independent verifier that bidder number 2 was indeed compliant. That provided surety to us at BAC that all processes have been complied. The allocations per region were also clearly identified by the BEC, and a structure and a process flow was given to give direction that a subjective process was avoided, and that a process in terms of allocating bidders to regions in terms of the preferential point system was applied. This then, of course, Chair, led to the final shortcomings that were picked up, the 3 bidders, 32, Al Shaddai Security Services, 35, Rapeshare Construction and Projects, 15, 2 Cops and Security at this stage were non-tax compliant. If they are non-tax compliant by law, we need to give them 7 days. We need to notify them, say you are a prospective bidder. You need to ensure that your tax matters are in place. We will be giving you a formal 7-day period. This process is duly handled by the accounting officer's office. Confirmations are sent, responses are received from their end, and confirmations are received. This is the process which led to the final award from the Bid Adjudication Committee side, Chair. On that, Chair, I want us to now go back to page 26 on the sworn statement. I will now be proceeding with the probity report, the first one. What I've done now, Chair, I've outlined the process from an end-to-end spectrum, from the bid specification right through to Bid Adjudication Committee, and what the law designates us to perform on each of those functions delegated as they are. On this aspect,
Before you go to page 26, where you had stopped was on page 18, you were dealing with the table. And then you set out the process that took place, or the summary of events in each committee. And remember, Chair said, I was hoping you will come back to this because you then went to the various annexures. For me, I need you to clarify paragraph 75, because based on what you have told us happened at the 3 BAC meetings, you can then influence the process, because you can say, why is this bidder not recommended? Why have you not given reasons for not recommending the one that has the lowest price? This bidder is non-compliant from a tax perspective. Give them time to do this and that. So can you then clarify what you mean by to demonstrate the fact that I could in no way influence the process? Because if you are a chairperson of the BAC and you participate in each of those meetings where you are able to send things back to the BEC, then it means you can influence the process. I would understand if you had framed the paragraph to read as follows: up to the stage of the BEC, you can't influence the process. But surely when it gets to BAC, you play a part there and you can influence the process to the point where you can even reject the BEC's recommendations.
okay. Thanks, Chair. Commissioner, I think firstly, we'll just need to understand how BAC is made up. BAC is made up of about 7 individuals. These are all senior managers within the City of Tshwane. They are appointed by the city manager. My role as delegated in terms of the SCM function is to be the chairperson of the Bid Adjudication Committee. So, Chair, influencing a process and directing proceedings in compliance with the relevant laws and regulations, from my perspective, is 2 completely different issues. So if we were to analyze and scrutinize documentations in front of me, applying the rules, laws, and regulations and prescripts of the law, it's not a process of influencing. It's a process of validating, providing assurance, and ascertaining that all key compliance mechanisms have been followed. So, Chair, with respect, I would like to maintain the statement that I do not influence, but I play an oversight in terms of ensuring that all due processes are followed accordingly at the stage of the Bid Adjudication Committee.
Please continue.
Thank you so much, Chair. I was on 105. On 105, I now deal with the probity report and the outcome thereof. Chairperson, Group Audit and Risk is a department within the city which is formally engaged and mandated to conduct a probity audit on the tender under consideration. In executing its mandate, GAR, short for Group Audit and Risk, further appoints an independent external legal firm to provide specialized legal support and to ensure an objective, comprehensive probity review prior to matters being presented to and considered at the bid adjudication level. It's an additional step that we have put on board as a result of the deficiencies that were picked up in the past in terms of shortcomings on matters of compliance. On page 106, Chair, I deliberate that the primary objective of a probity audit is to provide assurance that the work of the BEC adhere to all applicable supply chain management prescripts, legislative requirements, and governance standards. This includes verifying that evaluation process was fair, transparent, consistent, and compliant, that all bidders recommended for the award fully met the administrative, technical, financial, and statutory requirements of this tender. The probity process further entailed the identification and assessment of potential risks, irregularities, deviations, and the provision for corrective recommendations to ensure full compliance prior to adjudication. In this regard, it is important to note that the probity findings and recommendations carry significant governance weight and are regarded as authoritative. As such, they are required to be fully addressed and resolved and cannot be disregarded or overridden without appropriate justification and due process within the applicable regulatory framework. The detailed probity report has been attached as Annex to GM in the second bundle, GM 18. Again, Chairperson, with your permission, I would love us to go to GM 18, and it is situated on page number 367. On page 367, Chair, 368, you'll take note that Group Audit and Risk makes a submission to the accounting officer. It's a proactive forensic assurance review report into tender TMPD 01, 2024-25 for the Tshwane Metro Police Department. They further take note that the completed final proactive assurance review report form part that will notify your office on the 4th of April, meaning the accounting officer's office was given a go-ahead, an indication that the probity team will be conducting an audit or an assurance exercise before TMPD 01, 2024 is awarded. Attached, of course, is drawn to your attention the final report that has been presented. Within this report now, Chair, if I could explain in short, it's a mirror exercise by a team of external, independent individuals who do exactly what the BAC has done, meaning they obtain all documents that have been provided to them. They look at pre-compliance. They look at administrative compliance. They look at mandatory compliance. They look at the POE that has been provided for the fourth step in terms of physical site assessment. And then they look at the preferential procurement system and the allocation of bidders. That process is conducted from scratch by this independent external law firm in order to validate that all matters and all compliance issues have been dealt with accordingly. So within this, Chair, of course, we'll take note that findings have been raised on 372. These are the findings where the BEC must ensure that they're adequately dealt with before the matter comes to BAC for approval. That process undertakes itself, and if you look at this, Chair, they designate the process that is followed. On page 357, they clearly articulate the mandate and why they're doing this process. It's a critical function to ensure that we avoid incurring additional UIFW as a city. It's a significant step or internal control that was instituted. It wasn't previously there, Chair, at the City of Tshwane. We brought this new internal control on board in order to reduce instances of irregular expenditure that was ballooning to the top as a city. This was a new internal control that was brought on board. The work that is done here is clearly to articulate whether all functions have been performed accordingly. So if you look at the outcomes of this report, Chair, for argument's sake, I want to take you, without going to the details of the report, I have explained in short that it is an evaluation by an external legal independent party who's got no interest whatsoever at the city. They then come up on page number 387, for argument's sake. On 387, they're providing us with findings on the administrative compliance stage. And they say, we've taken note of these bidders. We confirm that these bidders must be disqualified for these reasons. This is mirrored and checked against the BEC report. Checklist exercise is conducted. There's an agreement in terms of all bidders that are disqualified, or all bidders that move over to the second stage of the bid evaluation process. This is a confirmation now that is obtained by the probity report. I'm going to move on to 391 of the same report. 391, item 11.5. Probity report gives guidance that the following bidders complied with administrative compliance and were therefore evaluated to go through to the second stage. They list the bidders 2, 12, 15, 19, 21, 23, 26, right up until 54. They confirm that they have checked all of these issues. Administrative compliance is in place. They are validating that as the probity assurance team. They then move over to 392 and saying on 392, mandatory requirements stage 2. They take note that, for argument's sake, bidder number 12 is not compliant, meaning they did not attach public liability insurance review. They cannot move over to the second stage. Work of the BAC is to validate whether this has been catered according to the BAC, which indeed it was. The next stage, Chair, I want to take you through is on page 393. On 393, on 11.7, they provide a list of bidders who were compliant on stage 2 on the mandatory requirements, who are now eligible to go through to the next stage in terms of the supply chain management process. They give the list of these bidders from 2, 15, 21, 23, 26, 32, 35, 36, and 40. Then the last stage, they also conduct a site inspection on their own, Chair. On their own, conduct a site inspection, they validate. I'm on page 394 now. On 394, the third stage of the probity report is to conduct site inspection and to validate. So if you look at this report on page 394, the proactive forensic assurance report, who are independent individuals, completely external from the city, confirm that 2 bidders, 21 and 2, are not compliant at this stage. Remember, we had taken note on bidder number 2 that there was an issue, and BAC had referred this report back, and we required an addendum report to give us surety that this matter had indeed been completed. Nonetheless, we'll then proceed, Chairperson, to page number 395, where they give us further report that bidder number 2 and 21 are non-compliant at this stage. However, the following we are happy with. On page 395, on 11.11, they provide an outcome of evaluation that the following 7 bidders complied with stage 3 of site inspections and were evaluated to go through to the pricing stage. They provide these bids. They conclude that the findings cast doubt on the integrity of the tender process undertaken in the city. While they are significant enough to make the process irregular and expose the city to litigation, the BEC may still correct the identified defects before submitting this report to the BAC for final recommendation. This is then the process that is undertaken, a correction, a removal, and a confirmation to align to what the independent party have brought on board to us as a BEC stage. They then give their final recommendations. They certify the report true and correct, Chair. I was just giving an indication before I go to GM90 of the final probity report, what their role is, how they fit in at the city as well. Chairperson will now, with your...
Just before that, are all these steps done serially or sequentially?
After PAC is concluded, Chairperson. That's why
I mean all the probity steps.
Yes.
The several probity steps that you've been dealing with.
Yes.
Are they done serially?
Chairperson, they are done after after the work of the PEC, not while the PAC is doing administrative.
No. I'm within the probity, the
Yes.
external entity. I'm talking about within the probity. Are the various steps that you've been dealing with done sequentially?
Yes, Chair.
There's this one. You knock off whoever needs to be knocked out. You move on to the next one. You knock off all the way, all of them sequentially.
Correct, Chair.
I would understand with just one example, For instance, when you have to go to the various sites,
Yes,
I would understand that that would have to be done separately.
yes, Chair.
I'm not so sure that you have to do all the others, which may well be a desktop exercise. I'm not so sure that they need to be done sequentially.
Chairperson, there's only 7 bids. So that's done in a day.
Or
The
within
site
a day.
assessment could be done in a day.
Okay, all right. I'm asking because I seem to recall that there was testimony that said there are lots of delays as a result of the probity exercise, amongst others. I think
Chair,
there was such evidence.
You'll take note that this bid closed on the 2nd of October 2024, but the final award was, from a BAC perspective, was made on the 25th of September 2025. But in all due respect, Chair, these are necessary processes to curb irregularities until we finalize the digitalization of our SCM platform. We rather deal with delays of this nature. We rather encourage proper planning by departments, wherein we encourage that a tender process must be undertaken 12 months before the end of a new tender, until we are certain that the digital process is in place and we can with certainty deal with issues of illicit activities and corruption. So these delays, Chair, are necessary. Without this property report having been done, we would have appointed bidders who shouldn't have been there, Chair.
I'm by no means suggesting that you should not have it, not at all. I'm not suggesting that. Yeah.
Yes,
I'm
Chair.
just, and of course, I think it was in the context of a different bid, not this one, if I'm not mistaken. But my point stands. I forget which. It was one of the very first witnesses from Tshwane who said that there are delays that result from the probity exercise. So that's why I'm engaging you on this.
True, Chair. But I thought these delays is necessary to at least ensure that there are no irregularities and that the city is not subject to litigations from errors which could have been avoided. This was a necessary internal control mechanism to reduce irregular expenditure, one, and to curb illicit activities, Chair.
Thank you.
Mnisi, I think, Mr. Mnisi, the point that the other witness made was the result of this delay is that the previous tender or the award, which has already expired, then has to be extended. And if you are spending 800 million a year, people whose awards have expired, you're now appointing them on a month-to-month basis for a period of a year, and you're spending 800 million that you should not have spent on them. So you're not only influencing the new tender, you're also influencing the old one, because if those who were appointed under the old tender would not have qualified under the new one, the effect is that they get an extension of a year. So there are those issues.
Chairperson, precisely our concern. It's a potential expenditure of 800 million. And were we to proceed with an award without this necessary assurance exercise, we'll be doing injustice. You'll take note that on the instance that we are referring to, I think it's TMPD 2 on 2016, that process was deemed irregular, Chair. And had this exercise been brought on board, it could have been easily avoided at that time. So we're always encouraging all departments to ensure proper planning until a point in time where we are able to have the digital systems on board to curb this where there's certainty. At this point, Chair, this is such an essential exercise. The city was sitting with irregular expenditure almost with 18 billion rand. The situation I, as the chief financial officer, as well as the city manager, couldn't afford for this to continue. Hence, the resolution is you must ensure that bids are advertised at least 9 to 12 months before they end, because we need to ensure that the proactive forensic assurance exercise is undertaken. Once we are able to confirm that the digital system is on board and we're able to deal with petty, inconsistent, illicit activities, we'll then deem this as an additional exercise. At this point, it is a necessary exercise. If we were to spend 800 million on a new tender, we need to be certain that all processes have been followed to the T. From the extension, Chair, if you look at our extension notices, in some instances, it's on a month-to-month basis. It's not really a blanket approach of saying you will now automatically get the new 800 million as the old bidders. It's a month-to-month, where we still give departments an opportunity to fast-track and finalize this process. Also, Chair, what I want to add is that mechanism of escalations of delays are there for departments to deal with. Departments, if there are delays, have the full authority to engage the Chief Audit Executive to put systems in place to fast-track matters of this nature. But the key exercise is that we need to deal with proper planning exercises, Chair. That's an issue that hasn't been there at the city at one point in time. And this is one mechanism that forces that through, and it's a double-edged sword in a positive way. One, we're able to plan accordingly. Two, we reduce irregular expenditure that is incurred by the city. But Chair, I think I will break down further within my statement on that particular tender and what actually transpired in each of the events where the extensions were considered by the BAC.
Mr. Mnisi, just to understand the sequence of the process. So the BC does its evaluation.
Yes.
And then they have a report. Is it at that point that probity is brought in?
Yes.
The probity authority is brought in at that point,
Yes.
appointed by the city manager
Yes. And the Chief Audit Executive.
and the chief?
Chief Audit Executive.
Okay. And then where does the probity report serve once it's done?
Once it's done, it's presented to the BEC. The findings
Yes,
are presented and deliberated at the BEC.
okay.
They are given an opportunity to make the necessary corrections. Once consensus has been reached between probity team and the BEC, then it's served to the BAC for further consideration.
Okay. So where you've had to return as a BAC, you've had to return a report or a process to the BEC to address the probity concerns. What does it mean for the process that you've described? Does it mean the BEC did not address the concerns in the probity report, but simply submitted to the BAC, and you then said, but you haven't addressed this? I'm trying to understand the process as you explain it. This is how it's supposed to happen, and what in fact would have happened in the situation that you explained to us, that you've had to turn it back.
Indeed, Chair, you're spot on. That's exactly what it means. It means BAC is identifying a notable difference between the final probity report and the BEC report. In this case, it was as a result of bid number 2 from Security Services, where that bid, from a probity perspective, said, nope, the irregularities here, you shouldn't award this. BAC says, no, we have had our interaction with the probity team. We have cleared this. But at BAC, they're not providing us with conclusive evidence that that has been dealt with accordingly. At BAC, we are sitting in front of us with the BEC report and the probity report. The probity report still indicates deficiencies within bid number 2. Hence, we refer that back for there to either be an official confirmation in the form of an addendum or a confirmation report from probity that indeed we had a discussion with BEC. We are now convinced that bidder number 2, Vamsira Security Services, for an example, is now compliant and should be awarded. They could have came back, Chair, and said, no, this bidder should not have been awarded. We maintain our stance that we did not confirm 1, 2, and 3 issues, which means the BEC must ensure correction. Probity report, as part of our internal controls, is authoritative in nature. Unless you've got substantive reasons to differ with that, then we'll allow that. Otherwise, Chair, a third-party confirmation is superior from all quarters of the accounting fraternity. The Auditor General relies on a third-party confirmation. This is a third-party confirmation that I would rather place my reliance on than an internal report as well.
Yeah, I guess what I'm trying to get right in my head is where the probity authority has said this bidder should not have been recommended because they did not submit 3 years audited financials. And then that's 1. 2, this bidder should not have been should not have been recommended because they do not have a 5-ton truck. Those 2 fact-based statements. When it goes back, when that report goes to the BEC, when you say as BAC, let this go back to the BEC to consider what in fact is the BEC to do with it? Do they approach the bidder and say, give us 3 years audited financial statements? Do you now have a 5-ton truck? And then come back to you and say, oh, now they are compliant? Or how exactly is the BEC to fix those two issues
Yes.
that are specifically flagged by property.
Thanks, Commissioner. In this case, the BEC was confident that all those non-compliant documents were there. They were confident, hence they say to BAC, we have met this, we are certain that 3-year financial statements and confirmation of a 5-ton truck is available. BAC then says, but that's not what property report says, so you go find each other with the property report. Meaning, you either come back with an amended property report signed by the external individual confirming what you are inferring to. If not, we will not move on with the recommendation of this bidder. That brings us now, Chair, to the next item on GM19, which we'll touch on it as well. So what happens now, Chair, I'm going to go back to page 27 with your permission. On page 27, I want to touch on my sworn statement. Sworn statement, page 27, paragraph 108. On paragraph 108, I now touch on the property report number 2. The Bid Adjudication Committee further required that the external legal firm appointed to conduct the property audit issue a formal written confirmation providing assurance that all findings and recommendations arising from the property review had been fully addressed by the Bid Evaluation Committee. Take note, Chair, I mentioned here that BEC came and verbally provided this surety. BAC said, no, give us an official confirmation from the third party. We can't just rely on what you are telling us now. On page 28, 109, the requirement was intended to ensure that independent verification that all identified compliance gaps, risks, and procedural deficiencies, Chair, had been satisfactorily addressed prior to the final adjudication. The BAC emphasized that such confirmation should explicitly attest to the completeness and adequacy of the corrective actions undertaken by the BEC, thereby reinforcing the integrity, transparency, and defensibility of the procurement process in line with the applicable supply chain management process. At this point now, Chair, I want to refer the committee to Annex GM19 on the second bundle. It's on page 397. On GM19, this is now the final communication or the second addendum where the property team confirms that we refer to the above matter in the comments of the Bid Evaluation Committee report dated 18th of September. We note that the following comments for the BEC regarding Vimsiri Protection Services C bidder number 2, according to our report dated 10th of September, the report, bidder 2 was disqualified in stage 2. However, the bidder was evaluated in the subsequent stages and recommended for the award. 2.2, confirmation of the data and details of the inspection conducted by the property audit team. 3, consideration of the above hereby clarify the issue raised. We confirm that at the time of the initial review of the tender documents of bidder 2, the property team erroneously concluded that the bidder did not submit audited financial statements for the recent 3 financial years, the AFS. As a result, the bidder 2 was disqualified, stage 1 administrative compliance. 3.2, however, following the further engagement and reassessment of the tender document, it was discovered that bidder 2 had submitted the audited financial statements, the AFS. As such, we evaluate bidder 2 in respect to stage 2 and 3. 3.3, in stage 2, we evaluate the bidder as follows. Mandatory requirements. Mandatory requirements in relation to a 5-ton truck. Bidder number 2, Vimsiri Protection Services CC, confirmed. 3.4, initially due to the erroneous disqualification in stage 1, bidder 2 was not evaluated in stage 3. However, in the report, it was erroneously stated that the bidder 2 did not have a 5-ton truck. Due to the reasons advanced above, we proceed to evaluate bidder 2 in respect of stage 3 as follows. Inspection, report for Vimsiri, bidder 2, Vimsiri Protection Services CC is confirmed. We conclude, Chair, that bidder 2 qualified in stage 1, administrative, and we hereby amend paragraph 11.4 of the report accordingly. 5, the following ratification in the error of stage 1, bidder 2 was evaluated in both stages 2 and 3 and qualified to be recommended for the award as per the report. This is now, Chair, confirmation that indeed the matter has been resolved between the BEC and the property team, and there is now alignment and this consensus between the two.
In this which you are reading, where You see, with respect to the audited financial statements, it seems documents were overlooked by the probity authority. That's how, my summary of what they're saying here. But then it's not clear how the basis for reversing the decision about having a 5-ton truck. It's not clear on this document. And yet the BAC seems to have accepted this as having cleared the thing. I think that's a difficulty that I have, that I'm trying to clear in my head about how this process in fact works. So, I mean, in this, and this is not me probing, it's again just seeking to clarify what these documents are supposed to represent and how the process works. So you have here, as I said earlier, one of the issues raised by probity was there's no 5-ton truck. Now this letter says, oh, this issue has become resolved. It's not clear on what basis, and when it gets to the BAC, what is before the BAC that satisfies the BAC that this company now does have a 5-ton truck and should be awarded the tender. It's something missing that's not clear to me.
Okay. So, Chair, in short, if you look at page 399 on stage 3, at the top they indicate at stage 3 inspection. What this tells us as BAC is that they went out and they verified this, Chair, and they confirmed this. In the earlier report, they say they did not even go out. If you look at page number 398, 3.4, initially due to the erroneous disqualification in stage 1, but the 2 was not evaluated in stage 3. This tells me, or tells us as the Bid Adjudication Committee, they didn't even go out. There was no need to go out and validate whether they have a 5-ton truck because they were already disqualified in the administrative review stage. However, they said it was erroneously stated from their side that the bidder did not have a 5-ton truck. That simply indicates, Chair, they did not go out at this time because they were disqualified on that basis. On 398, stage 3 inspection, that's a confirmation that they went out. From a bid adjudication process review and us scrutinizing the submissions that we received, this gives us surety that, 1, they have assessed the audited financial statements from an administrative perspective. 2, they went out to confirm that the mandatory requirement of a 5-ton truck was available. Hence, they're putting their head on the block and giving us surety that this has complied to the T. Hence, the BAC placed reliance on this as a confirmation to resolve, I don't want to say the conflict, but rather the area of concern that was picked up.
All right, thank you.
Chairperson, I then finalize on 109. And now, with your permission, I want to go back to what you had requested, Chair. Now I'm going to go back to what you requested. I'm going to go back to 2 aspects. Remember, initially I stopped us at paragraph 61, but I want to quickly summarize on 71 and then go back to 61 so the normal proceedings can proceed. On 74, Chairperson, these are the summary of the events. And me indicating this and clearly articulating on them between now and paragraph 109 and us deliberating on the various annexures was to articulate the process that was embarked upon, the segregation of duties, the process and the deficiencies that might have been picked up or been dealt with accordingly. So that was to articulate what happens when a bid of this nature, complex bid of this nature is awarded, and what are the strict processes that must be followed. So this is an indication, Chair, that all processes from A to Z have been followed, that the bidders that we have on board are confirmed indeed as eligible prospective bidders in line with the step process that we've just articulated. So, Chair, with your permission, I was concluding on at paragraph 61, and I had to bring this discussion aboard because there is a linkage and an alignment between paragraph 61 and the outcomes of paragraph 71 to 109, and I had to deal with these 2 together and also outline the various annexures, the processes, and the assurance activities that we undertake. So, Chair, I want to stop here and maybe request through the evidence leader that I proceed on paragraph 62.
By all means.
Sorry. Still in that paragraph 61 where you say he was of course wrong, the process that you've described of the going back and forth to the BAC, to the BEC, it sounds like it might be open to you to anyone, when I say you, I mean any member of this process, to be able to check whether a bid has been found to be compliant even before a decision is made.
So
It
Chair, in
seems
short-
to me that way. Yeah.
Sorry, Commissioner, I just want to allow you to proceed. I think I
No,
interjected.
if you've heard what I'm suggesting, it's fine, you can respond.
Commissioner, that's the final stage. And at that final stage, all administrative compliance, all mandatory issues, pre-compliance, physical site inspection, they're completed. There's nothing to check at that point. Hence, I'm stating in my statement that it was of the mistaken belief that I would be in a process to check and advise on where this process is, how far it is. Due to the delegation of authorities, segregation of duties, the report comes to me on the 4th of September for the first time. Literally, on the morning of the BAC. Those are the systems that you put on board. I, as the BAC chair, nor any of my members in BAC have access to any of those documents except on the morning when we sit as the bid adjudication committee. These are also the internal control measures that we had to put on board to eliminate instances of this nature.
Does what serves as the BAC that you see for the first time, the set of documents or report, does it include information about these were the bidders?
Yes.
This is so-and-so, these were disqualified with the detail of those bidders, and these are the reasons. Is it that kind of information that serves before the BAC?
Yes, Chair, it is. It's the complete pack that is dictated for in the summary of the events on paragraph 74.
All right, thank you.
Just one small matter. On average, I would imagine, of course, that there may be differences depending on the bid at issue. But on average, what's the time lapse between the closing date and the time that the BEC starts working on a bid?
Chair, by law, 90 days must be the process that bidders.
I'm not talking finalizing.
Okay.
I'm talking beginning to work on a bid, the BEC.
So once members are appointed, the committees have been established, they can commence
On average, do you
within 30 days.
within 30 days?
Yes.
All right. I'm not probing, but I'm asking in the context of suggestions that something must have happened somewhere between. Of course, this relates to a different bid, not the one of looking after property in the context of, what do they call it now? The hijacking of buildings.
Illegal
That's what
invasion.
this is about.
Yes.
This one is about. In a totally different context, there are suggestions that something may have happened between the lodgement of a bid and whatever point during the process. And I suspect it must have been before the BEC started working on the bidded issue in that context. I'll just make that comment and leave it there. Please continue.
Thanks, Chair. Maybe just to summarize on that comment, Chair, as soon as bids are closed, I mentioned in that bid.
And perhaps let me just conclude my comment by saying, and 30 days is a very long time for a lot to happen between the closing date and the time that the BEC starts working on the bid. Yes, please continue.
Chair, the point I was trying to raise is that as soon as closure is done, documents are stored under lock, safe, and key. That's an area that is only accessed through official register. There are officials who sit there and sign off any individual who goes in and out before evaluation proceeds.
We will deal with it when the probing comes.
Okay. Chair, I was going back to paragraph 62. On paragraph 62, I'm addressing the matters at paragraph 2.12.2. On 2.12.2, the request was that I must give details whether you have assisted directly or indirectly any of the bidders in respect of TMPD 02, 2016-17, TMPD 01, 24-25, and TMPD 03, 24-25. This is as per the 10-6 notice. On 62, I start dealing with at paragraph 2.12.2. 62, I respectfully point out that the above mentioned bid was awarded prior to my award within the city, prior to my appointment within the city of Tshwane. I accordingly confirmed that I was not able, nor would have been possible or practical for me to assist either directly or indirectly any bidder in relation to the said bid at the stage of its original award. I do, however, place on record, Chair, that I later and more fully explained below participated in the consideration of extensions of the said bid. This was as a result of the fact that a replacement tender had not been finalized and put in place at this stage. To avoid any misunderstanding, I deem it necessary to explain the ordinary process which must be followed. In relation to extensions of an expired bid, any specific. In this instance, Tshwane Metro Police Department submitted a request for the extension of bid to be considered by the BAC. In my capacity as the chairperson, I presided over the meetings at which the requests for extensions were considered. My involvement in that regard was confined to the discharge of my official responsibilities within the prescribed governance and committee processes applicable to such extensions. Paragraph 66. Officials from TMPD make the necessary representations, Chair, setting out the reasons why extensions must be made for TMPD 2, 2016-17. These presentations are then considered by the BAC. After due consideration, will make a recommendation in accordance to the applicable process. The final decision in this respect, of course, of approval of any such extensions does rest with the accounting officer. I state, Chair, for the record, that all submission applications in relation to the extension or the relevant contract were prepared, managed by the duly authorized representatives of TMPD in accordance with their respective responsibilities. In my capacity as the chairperson, I presided over the following meetings at which extensions were considered by the BAC. In total, there were about 5 extensions which were brought. These extensions, I want to reiterate, are brought on board by the user department, in this case, TMPD. They come to BAC, they say, this tender is expiring, we still need the service, please can you extend this project as a result of this not being finalized. On the first instance, on the 20th of February 2025, an official who is delegated by TMPD comes to BAC, Mr. Veli Nandule, requests for an extension. This extension, Chair, is not granted. An GM4 has been attached, and I would like us to go and discuss the reasons why this initial extension was not granted. On GM4, on the paginated bundle for the second bundle, I think this has been captured under at the beginning. So at the beginning of the pack, Chair, on page 38, I've got GM4 that has been attached for the commission scrutiny, page number 38. So on page number 38, you can see that the individual comes to BAC. He asks for an approval on the expansion of TMPD 02 for a period not exceeding 4 months with effect from the 1st of March. He further asks, or TMPD further asks for an additional amount of 227 million rand within this period for the extension of these services. 3, it gives us a cost center or a GL, which we utilize to pay for this extension services. 4, they also request for an envisioned price escalation in line with the CIRA rates for the period of appointment. They then give a list of the bidders that must be attended to or extended. BAC raises significant exceptions on these requests that are being brought on board. First of all, Chair, budget issues are not considered by BAC. This is a procurement committee that is there to look at supply chain management regulations, supply chain management policy and functions of that nature. Can't come to BAC and ask for additional funds. That's a process that you need to undertake either with the accounting officer or during the budget period. Secondly, as for price escalation, which is something completely out of the purview of BAC. So during those discussions, Chairperson, this report is referred back on the basis that Firstly, there were inconsistencies in terms of the start date of this particular tender. Secondly, the approval for upliftment of funds and an additional request for 227 million was outside the purview of BAC. Thirdly, an amount of 227 million rand was not clear to us, Chair. It was not clear to us, Chair, that this falls within the 15% variation. We also noted that failure to re-advertise the tender on time indicated a massive element of poor planning from the BAC perspective, and that all budget-related issues are not covered here and should be removed completely. So for those reasons, this report is referred back for the colleagues at TMPD to reconsider their submission and make sure that it's within the ambit of the law. I then go back, Chair, to 67 on page 16 of my sworn statement. On this, Chair, I want to discuss the second sitting where we're considering this extension on the 27th of February. Mr. Veli Nwandule comes to PAC, supported by the Deputy Chief Umashi Dlamini, for a request or to clarify on the issues that had previously been rejected on this particular bid. Again, Chair, with your permission, GM5 has been attached as an annexure. I would request that we go to GM5, scrutinize the details of that annexure, and assess its relevance to my submission today. GM5.
Just a minute. Mr. Chaskalson, do you think perhaps I should address this to you too, Mr. Van der Geven. Do we want to go to the detail of why the various requests were made and also why they were either approved or not approved? Do we want to deal with all of those individually?
Chair, I can't say no. I mean, yes. I don't intend to address all of them, yes, but there will be some which may be relevant.
All right. Yes, Mr. Minister, please continue.
Chairperson, I'm on bundle 2, page 40, references GM5. On GM5, TMPD officials come back to PAC, clarifying on the issues of concern. And amongst those issues on concern, they are in short stating to the PAC that these were your concerns and these are our responses to those concerns. First one, at the bottom, if you go to page number 41. On page 41, we summarize the discussions of that engagement. And during these discussions, on the meeting held on the 27th, amendments were done as recommended by the bid adjudication committee. They're providing us with assurance that these issues have been dealt with accordingly. Secondly, the previous indication stated that the contract had expired was correct, and therefore the report stated that the tender was still valid. Until 28th of February 2024, and therefore does not require a request for deviation. There was a concern from PAC that this contract had expired. You must ask for a deviation. They then clarified to us by providing the SLAs that this tender was still valid. The department further confirmed that the amount requested, Chair, was below the 15% mark threshold and was within the variation or the scope as allowed by the law. SLAs from service providers stated that the date for resuming duty was the 1st of March. The department also confirmed that due diligence wasn't done in confirming that all SLAs contained commencement date of 1st of March 2022, which of course gave rise to the concerns which were raised by the BAC, thereby confirming that all 22 contractors commenced their duty on the 1st of March 2022. Thereafter, the committee requested that the department to provide the SLAs stipulating the commencement date of the 1st of March for all 22 bidders for the filing and packaging, that the contract has moved from the regional date to the new date and that it was imposing challenges in dealing with them, that we confirm that the signed SLAs were signed by the former acting city manager, and thereafter delegations were made to these SLAs to the relevant TMPD officials. Metro Police Department should verify and provide the status of the people or the persons who are currently signing SLAs on behalf of the city in terms of their delegation of authority. Verification of the persons who signed 22 SLAs be sent to members of the committee as per the recommendation of the report. that copies of all SLAs confirming that the contracts commenced on the 1st of March must be part of the approval pack. The department must provide confirmation that the amount of 4 months extensions was still within. These were all matters, Chair, that were provided to accordingly. They could be adequately addressed and validated by the BAC. Hence, you'll see that the resolutions from 42 to 44 have been catered for accordingly, and that it is granted. The point of this, Chair, is for me to prove, to show the committee the process of extensions. That extensions cannot be done by a one-man show. There is an articulate process and system that have been designed within the city to ensure that extension applications are considered. Also, extension applications that are considered are not just approved, they are intentionally scrutinized and probed for any deficiencies which results to issues of this nature. Chairperson, I will request to go back to my sworn statement. On my sworn statement, I now want to deal with page number 16 again. On page 16, I want to touch on the third time when an extension application is brought to the BAC. I'm on page 16 of the sworn statement. On the 26th of June, Mr. Rivo Space comes to BAC, request for an extension application for the existing tender as well. GM6 has been made available for the committee to scrutinize. Maybe, Chair, if I can touch on the 25th of September as well. So there are two instances where the Deputy Chief Rivo Space come to BAC on the 26th of June, 2025, and the 25th of September, 2025, requesting for an extension application on TMP, on the TMPD tender under scrutiny being TMPD 02, 2016-2017. I will then want us to move back to the second bundle so we can scrutinize the GM6 as well as GM7 and what the contents of discussions were, Chair. GM6 and GM7 start on page 45, Chair. On page 45, we then start with GM6. And you'll take note there's a big difference on this, Chair. This does not come as an extension application anymore. It comes as a Regulation 36 supply chain management request. It's an outright deviation to appoint these same bidders. The reason for this is that BAC could not allow another extension on the basis that, firstly, we advise the committee to ensure, we advise the department to ensure that they put systems in place to advertise the tender and fast track the appointment process, one. Secondly, the 15% variation was depleted. There was no way that we could provide another extension. So TMPD then came on board knowing that with an outright deviation. So apparently from their perspective, they still needed the service. And within that service, as a result of the new tender not being finalized, came to BAC asking for an outright deviation. Within this, Chair, BAC of course scrutinized the application, has significant discussions with the TMPD presenter, in this case, the DC Rivo Space. And the deviation report is articulated as due to the reasons of finalizing the procurement process and delays in the probity report are some of the reasons that are provided by the DC Rivo Space. However, taking into account the above, there is a huge element of poor planning that will be considered by oversight bodies or auditors like your Auditor General. The BAC then recommends that this will attract Regulation 32, meaning it will be irregular expenditure. No matter what motivation you can bring on board, there's no way you can convince a third party that it's as a result of internal processes. It's poor planning. It will be irregular expenditure. It must be investigated as such. We'll take note, Chair, that recommendation number 5 on page 47. As much as BAC provides the approval, taking into account the significance of this tender as presented by DC Rivo Space, that city's assets will remain unprotected. We have to raise an issue that this will attract irregular expenditure. It must be investigated accordingly. It must be reported to the Municipal Public Accounts Committee. It must be recorded and referred to Group Audit and Risk for further investigations. And it must be disclosed in the city's annual financial statement as such, any expenditure towards this. It is then approved and recommended to the accounting officer, who then approves it accordingly on page number 49, with the recommendation that this is an outright irregular expenditure. It must be investigated in line with the processes of Section 32 of the Municipal Finance Management Act. Similarly with GM7, hence I'm touching the instances of the 25th of June and the 25th of September concurrently. Similarly on the on GM7, GM7 is on page 50, Chair. On page 50, we'll take note that the DC reverse piece come to PAC again, and the reasons why there has been delays and that motivates for this extension is a result of the probity process currently undertaken. It has not been finalized, it's still in the process of being validated. Hence, they came back and they asked for another extension in the form of a section 36 outright deviation. Similarly, PAC probes this and provides a similar recommendation that the service is indeed key. We don't dispute that from the department. However, supply chain management prescripts in the law, there has been deficiencies that have been identified. There's no way that we can account to this not being irregular expenditure. We then recommend under item number 5 that this must be treated as section 32 of the MFMA. Irregular expenditure must be implemented according, it must be referred to the relevant structures for further investigations. Further, it must be disclosed in the city's annual financial statements as part of our irregular disclosure note. And recommendation is made to the accounting officer by myself acting on behalf of PAC. The accounting officer duly approves the extension application for the second time on the 25th of September. The last time the extension application is brought on board, Chair, is on the 27th of November. I want to now move back to my sworn statement on page 17, and I deal with the last aspect of this extension application. On page 17, 27th of November, Mr. Vusi Mabona, also a delegated official from TMPD, supported by the Deputy Chief Revo Spies, comes to PAC. They ask for another extension as a result of this tender still not being finalized due to the various processes that are still being undertaken. GM8 has been attached, and it's the last item on this process that I would love to refer the Commission to the second bundle, which has been adequately captured on page number 54. On page 54 of the second bundle, we've got GM8. On GM8, similar process is undertaken. The department motivates, they tell PAC that they are aware that it will attract Regulation 32. However, they cannot ensure that the city's assets are unguarded. They are aware that this will attract irregular expenditure as with the previous approvals. Approval is then granted accordingly as Section 32, as a Section 32, as stated in Resolution number 4 of GM number 8, captured on page number 56. Equally, Chair, PAC is clear that this extension or this appointment, this is not an extension, it's an outright deviation appointment. Just to get the wording correct, for the last 3 instances, it will attract irregular expenditure. We are referring it to the relevant authorities for further investigation. Prudently as well, we need to disclose this in the city's annual financial statements. That, Chair, now deals with paragraph number 67. So I'll go back to my sworn statement on paragraph 17 and finalize paragraph 68, 69, and 70. I will not be referring to any annexures for these
Mr. Minister,
paragraphs.
maybe clarify this before you go to your answer. Am I correct that the effect of the first 2 extensions and then the deviation appointments, the effect of them was that those security companies, 22 of them, would provide the contracted services, but they could also be appointed to do the ad hoc security services?
Yes.
So you couldn't go to somebody new for the ad hocs, you had to appoint this 22.
This was the same process that we're doing. Also, Chair, just for you to be aware, it's also an ad hoc appointment, meaning as and when.
Yeah.
So ad hoc is provided on the as and when basis as a result of these service providers having been appointed in 20, whatever that time was, Chair, I just don't have the date, on an as and when basis. So yes, you are correct. It is the correct Watchman Services tender, as well as they could tap into ad hoc for utilizing this tender.
Oh,
Now that you've again referred to the as and when, I'm just, is it truly as and when pricing, or is it as and when invoicing? Is it literally pricing? Because I would find it very strange that an organ of state would get into a procurement relationship with several entities, not knowing how they would price I'm raising this because I would understand if it's as and when invoicing, in the sense that the pricing itself is already known. Do you follow me?
Yes, I do, Chair.
Yes. Can you just clarify that?
Yes, Chair. The pricing is certain. So we
It's
appoint on rates, meaning the pricing is certain. We know exactly.
Then perhaps you need to change your language and not refer to as and when pricing.
Okay.
That's why I was confused earlier, and I even asked you the question, what exactly is this as and when pricing?
Okay.
Thank
So,
you.
Chair, the basis of this was the result that risk assessment changes. A point could be a hot potato today, but tomorrow could be a low risk area, meaning reassignments are probable and can be done. Hence, you allow the as and when. But the pricing.
I understand that. It's only if you've been engaged, and once you have been engaged, then you invoice.
Yes,
So the as and when, but as and when invoicing, not pricing. The pricing is known. Do you get me?
I get you, Chair. The pricing is known. Yes.
Thank you.
Chairperson, I'll proceed. I'm on paragraph 68 on page 17 of my sworn statement, and I will cover 68, 69, and 70 before I proceed to 71. I further confirm, Chair, that I did not, whether directly or indirectly, champion, initiate, or influence the process of extensions of TMPD 01, 20, 02, 2016-17. At no stage did I take any steps to promote advance the said extensions, nor did I exercise the improper influence in relation to that process. My involvement in the matter was me acting as chairperson of the Bid Adjudication Committee. This only happened after the relevant report had been formally presented before the Bid Adjudication Committee for consideration. My role was therefore confined to that of presiding over the BAC process and discharging the responsibilities attached to that office. I was not the person responsible for initiating, leading, or motivating any extension application. Any steps taken in relation to the preparation, submission, or advancements of extension application, Chairperson, are undertaken by the relevant TMPD officials within their operational and administrative mandates as outlined above.
And I think at that point, let us take the lunch adjournment and resume at 2 p.m. Let's adjourn.
Thanks, Chair.